Welcome to this explainer. Okay, so today we're diving into a topic that, let's be honest, a lot of us tend to put off, but it is absolutely critical for your family's future, and that's estate planning. I want you to think about building an estate plan kind of like building a house. You wouldn't dream of constructing a gorgeous home without a really solid, architecturally sound blueprint and a rock-solid foundation, right? Because without it, the very first storm that rolls in could just bring the whole thing crashing down. Well, your life's work, your assets, your family's financial security, they require that exact same level of deliberate planning.
But here is a pretty dramatic reality check for you. If you do nothing, if you fail to create your own plan, well, the government already has a default blueprint ready and waiting for you. And trust me, you are probably not going to like their design. If you lack a plan, state laws literally step in to make all the critical choices about your money, your property, and even your family without a single ounce of your personal input.
So here's our roadmap to fix that today. We're going to cover the cost of doing nothing, trust fundamentals, choosing your trust type, avoiding dangerous shortcuts, and finally, building your actual plan.
All right, Section 1, the cost of doing nothing.
Let's start by looking at the absolute chaos that unfolds when a life is built without a legal foundation. It is so easy to think, I don't need to worry about this yet, but the consequences of procrastinating are severe. If you pass away without a will or a trust, you die in what the legal world calls intestate. And when this happens, the laws of intestate succession kick right in. That means the state decides who gets your assets, not you. A probate court will just carve up your estate according to a super rigid legal formula. And this might completely contradict your actual wishes. Want to leave something to a close friend, maybe a favorite charity, a stepchild? Well, without your own plan, the state says no. Your assets only go to legally defined relatives, whether you actually had a good relationship with them or not. And the stakes get even higher and honestly, deeply personal if you have minor children. Because without a plan, a judge picks who raises your kids. If tragedy strikes you and your spouse, the court is going to appoint a guardian. They might pick your in-laws, who you completely disagree with, or maybe a cousin who is just terrible with money. The court won't have the benefit of your input. By creating a plan, you hold the power to designate the exact people you actually trust to raise your children and manage their finances.
Okay, let's dive into Section 2, Trust Fundamentals Explained.
To get out of the state's default system, you need the right tools. You've probably heard the word trust thrown around a lot. Simply put, a trust is a legal entity that holds and manages assets according to your written terms. Think of it like a massive heavy-duty vault. You build the vault, you lock your family's valuables inside, and you write a highly specific instruction manual on exactly who gets to open it, when they can open it, and what they can take out. And crucially, because the vault technically owns the assets, your family completely bypasses the public, time-consuming process of probate court.
Now, when we compare our two main tools, the will and the trust, a really vital distinction emerges. A will is great, but it only takes effect after you die, and it essentially acts as an admission ticket to public probate court. A trust, on the other hand, works while you are alive, managing your assets if you happen to become incapacitated, and it operates entirely in private after you pass. But here is the absolutely crucial point. Even if you have a powerful trust, you absolutely still need a will. Think of your will as a crucial fail-safe. It's a catch-all net designed to scoop up any leftover assets you might have forgot to put into your trust, like, say, the cash in your wallet or a newly purchased car, and pour them safely right back into your trust.
Moving right along to Section 3, choosing your trust type.
So, let's look at the different rooms you can build into your estate plan based on your family's unique needs. Not all trusts are created equal. Just like a house can have a nursery, a home office, or a gym, your estate plan can utilize totally different trusts. We've got the irrevocable trust for permanent tax planning, the special needs trust to protect government benefits for disabled loved ones, charitable trust for giving back, and spendthrift trust to protect beneficiaries from their own poor financial decisions. But the most common choice, the living room of your estate plan, so to speak, is the revocable living trust. It's the most popular because it maintains your flexibility. You can change it, amend it, or completely tear it down at any time while you're still alive.
Next up, Section 4, Avoiding Dangerous Shortcuts.
Now we need to talk about construction errors. I want to strongly warn you against using cheap building materials. Trying to outsmart the legal system with DIY shortcuts almost always ends in disaster. People often think, oh, I'll just add my daughter to the deed of my house or my bank account to avoid probate. Well, that is joint ownership, and it is a massive hidden danger. The moment you add your child to your title, your house becomes vulnerable to their personal financial storms. If your child gets divorced or sued or goes bankrupt, their creditors can literally come after your home. Or consider life estates, where you give your house to your kids but retain the right to live there. Sounds smart, right? Until you realize you've completely lost the freedom to sell or refinance your own home without their legal consent.
Now, I want to talk about the number 5. This is perhaps one of the most terrifying numbers in estate planning, specifically when we're talking about long-term care and aging.
That number represents the notorious Medicaid 5-year look-back period. Nursing homes are incredibly expensive, and many people eventually rely on Medicaid to cover those costs. But Medicaid has strict wealth limits. So, a common, really dangerous shortcut is thinking you can just give your house or your savings away to your kids right before you need care so you look poor on paper. You can't. Medicaid looks back at your finances for the past 5 years. If they see you gave away assets, they will slap you with devastating financial penalties and delay your coverage. You have to plan well in advance to protect your assets properly.
Let's move to our final section. Section 5, Building Your Estate Plan.
It is time to pour the concrete and see how this all builds together. How do we actually get this done? Here are the 5 specific steps to establish your trust and secure your blueprint. First, determine your goals. Who gets what and when? Second, choose the appropriate trust type, usually with a professional. Third, draft the actual document containing all your instructions. Fourth, execute it properly by signing it in front of a notary public. But it's this 5th step that is the absolute most important part of this entire explainer. Step 5, fund the trust. I literally cannot emphasize this enough. As our source material clearly states, properly funding a trust requires more than simply listing the assets. Creating the trust document is just like buying that heavy-duty vault we talked about. Right now, it's empty. Funding the trust means you actually have to go to the bank, go to the county clerk, and physically change the ownership titles of your bank accounts and real estate from your personal name into the name of the trust. If you don't put the money inside the vault does absolutely nothing and your assets go straight to probate court.
So do you need an architect for all of this, or can you build it yourself? DIY kits are out there, and look, they're fine for very simple, small estates without tax issues or complex family dynamics. But if you have a large estate subject to estate taxes, if you own a business, if you have a blended family with stepchildren, or if you are trying to disinherit someone, professional help is essential. An estate lawyer knows the building codes of your state. For instance, some states have incredibly complex forced heirship laws, and hiring a pro is going to prevent costly, permanent mistakes.
We've covered the foundation, the tools, and the building process, which leaves us with one final thought. Your legacy is being written every single day. The blueprint for your family's future is going to be drawn up one way or another. So who holds the pen? Will it be a cold, rigid state formula drafted by the government, or will it be you? Take control of your estate planning blueprint today and build a foundation that will protect your family for generations. Thanks so much for joining me for this explainer.